We are finally here. Part 3 of the Employment Relations Amendment Act series is coming to an end with this episode, and this is the last topic that I received the most questions about. And in this episode, we are covering remedies and what employees get awarded if they derail a process or engage in some sort of serious misconduct. There have been some movements with case law, and it's getting interesting. So stick around because this one is worth the deep dive. Hi everyone, welcome back to Lawlands. I'm Sanam, and this is the Employment Law Done Right podcast, where I help businesses get their people decisions right. I'm here to give you the legal thinking without that legal bill. Personal grievance remedies under the old Employment Relations Act regime felt very misaligned to a lot of employers, and I get why. For anyone that runs a business or that leads people, works in HR, you would understand how frustrating it can be when you are trying your best and putting your best foot forward in working constructively with an employee and they start to derail a process, or they lie and you know that they're lying, but you may have done a misstep in a process and now the whole thing has fallen by the wayside. You run a good process, reach the right outcome, but then lose because of a technicality. And the employees that are behaving badly, they could be reinstated, compensated large amounts of money, and it really leaves you frustrated. Trust me, I have been there and I was just as frustrated as many of you are. But the 2026 legislation that came in, which I'm calling the Amendment Act because it is long-winded, it made two major changes in relation to this topic. And it changes up what remedies are available when an employee actually contributes to the situation. And it changes the justification test so that the technical process errors aren't actually automatically considered fatal. So these two changes work together, and there's been a massive change now under this legislation. But let's get into the law and what it actually says. And the way that I'm breaking it down is that there's two tiers of contributing conduct. The Act introduces two levels of contribution, and they come with different consequences. Level 1 is contributing conduct, but it's when it's not related to serious misconduct. In this particular case, under Level 1, if an employee's behavior contributed to the situation that gave rise to the personal grievance and it's not considered serious misconduct, then the employee cannot be awarded reinstatement. They cannot be awarded compensation for hurt, humiliation, injury to feelings, which is what we usually see under Section 123. They are able to claim lost wages, but the authority can actually reduce that amount and the award by up to 100%. So level 2 is when we're talking about serious misconduct contribution. So we are talking about contributing conduct, but it is serious misconduct now. If an employee's conduct amounted to serious misconduct and contributed to the situation, the authority is now legally barred from awarding any remedies at all. I'm talking about no reinstatement, no compensation, no lost wages, nothing. This is a complete remedy exclusion. It's not a reduction, not you may get lost wages and will reduce it slightly. This is completely out the door exclusion. The section that we're looking at there is Section 123B, and serious misconduct that is contributing to the situation that gave rise to that personal grievance. The authority there must not provide any remedies at all, lost wages included. The whole thing is gone. When we get into really breaking this down, let's first look at the obstruction factor, because it's a lot of, what did the employee do? How did they contribute? All that kind of stuff. So when we look at the obstruction factor, what do we look at? The Amendment Act now adds in a new element to that test of justification, which is Section 103A. The authority now has to consider whether the employee obstructed the employer's ability to carry out a fair process when assessing whether the employer's actions were justified. I saw a case a while ago. Somebody sent it to me. They were very chuffed. They were like, look at how amazing I was at taking my employer to court. And for me, we know I'm very much pro-employer. I would rather the employer learn and give them the training and the teachings and the confidence to actually tackle the situation properly. But in that specific scenario, the reason why I bring it up is because the employee was so heavily involved in derailing the process that it got to the point where even the authority member had called it out and said, look, we are reducing compensation slightly because what you did in the beginning was make things difficult, But because of the test at that time, the employee was paid compensation. They used the old section 103A, the old justification test. And in that situation, a minor procedural defect wouldn't make a dismissal unjustified if it didn't cause unfairness. The 2026 amendment legislation basically removes the word minor. So any procedural defect, minor or otherwise, as long as that defect does not result in the employee being treated unfairly. The question then shifts from did you follow every step to did any step you missed actually cause unfair treatment? That's a meaningful change, right? That's a massive shift, but it's not a permission to skip steps. And I think that that is where we now understand the distinction a lot better. That any procedural defect, minor or otherwise, doesn't render a dismissal unjustified, but only as long as the defect didn't cause unfairness to the employee. And that is what the test has become now. So on the timing of all of this, we know that the Act applies immediately to any dismissals after the 21st of February 2026. Currently, if you are in active ERAA proceedings and the dismissal happened before the 21st of February, the old remedy structure will apply, unfortunately, in your case. So I wanted to do a bit of a case spotlight and have a look at a few cases before I get into my take and what we need to be looking at. One of the cases that I wanted to have a look at is it actually is a dismissal that happened after the legislation came into place. So this is to do with port workers, and basically two port workers refused to work with a colleague. They said it was unsafe and the refusal was on the 8th of January. The dismissal actually landed on the 27th of February. So this was 6 days after that law came into place. And those 6 days put them squarely under that new regime. And the workers argued most of the conduct and most of the process happened under the old law. The authority said no, the dismissal date was after 21st of February. It's about when you pull the trigger, not when the trouble started. So if it's to do with the dismissal, it's when the dismissal took place. What we don't know yet, and we need to be honest about this, is that there are no landmark employment court cases or employment relations authority decisions that have applied to this new contribution provision. 4 months in, and we're still waiting. But what we have right now is legal commentary, and we have some cases that have referenced these particular laws coming in, even though it may not have applied. So the legal commentators have said it is clear that the employment court will likely apply these provisions strictly, the same way it applied the strict compliance provisions and standards to 90-day trial periods. Under the old law, serious misconduct was a label that affected the edges, right? You're looking at justification, contribution, the size of the payout. Under this new regime, it's basically an on-off switch for the whole remedies regime. So serious misconduct that contributed means the employee gets nothing. Most people are thinking that the court will look at the context. What happened, why it mattered, whether there was intent or recklessness, and what a reasonable employer could fairly treat as employment relationship destroying behavior. If we look at it, an employer could argue the employee contributed, so no compensation. Compensation is off the table, even if our process was poor. But the employee could argue that you actually didn't follow the law and do what you were meant to do. And because of that, it's caused me severe unfairness, right? So the court is expected to keep these concepts separate. Contribution should not become a mechanism for excusing major process failures unless the employee's conduct genuinely created or materially worsened the process problem. This, again, it'll be tested, but watch this space. A couple of areas where this has come up, and I think that that's what we need to start having a look at. There was an Insight New Zealand case that came up against John Stone, and that was decided on the 20th of May 2026. Now, it's 3 months after the legislation came in, and the employment court had a look at it, and it was about a residential worker with almost 21 years service, and one morning, a vulnerable resident ended up on the floor at the breakfast table. She and a colleague ran the first aid checks. The resident seemed fine, went about his morning, went to his marae, and 2 hours later, he collapsed and was hospitalized. The employer dismissed her for serious misconduct. The colleague who saw most of it got a written warning. Interesting. And this case was not decided. It was not decided under this new framework. It was decided under the old framework because the events were back in 2023 and the dismissal took place beforehand. It is the employment court spelling out what deliberate means, and that is why it is important. What the judge said in this case was that there is a long-standing test that we've got since 1992. It was the BP oil case that came out, and the reason why we're focusing on deliberate is because a lot of people have raised the same exact point, and it is a valid point. What is classified as serious misconduct? I read a case from last year or the year before where serious misconduct in sexual harassment cases was considered serious misconduct. It was commonsensical. It didn't need to be blatantly said that this is serious misconduct. But when we start getting into the nuances of your industry and your workplace, serious misconduct can kind of differ, right? And so this is where we use this particular commentary or what this judge has said around deliberate. And the judge used a long-standing test from 1992. It was a BP oil case. In that case, serious misconduct is said to be a deliberate action that destroys the trust and confidence at the heart of the employment relationship. I know in HR, we always throw it out. I throw it out too. We love to sprinkle it in our letters and say the infamous lines that undermines the trust and confidence in the employment relationship. And there are two parts to that, because what that means is that a state of mind needed to be deliberate, and a consequence took place, which is a destruction of trust. And in order for it to be serious misconduct, it really needs to have both. It needs to be that the state of mind was in such a way that it caused this deliberate action and that the consequence truly destroyed the trust and confidence. In that particular case, the court found that this worker's conduct wasn't deliberate at all. And so here's how the judge broke down the employer's case. Firstly, they looked at the employer's dismissal letter. They saw what was written, recorded as established fact that the resident had been unconscious. The evidence didn't support that. So you can't really build a case of serious misconduct on a fact you haven't properly established. The next thing that they looked at was the ambulance policy. The whole idea about calling the ambulance and the protocols and what was needed, that wasn't a written rule. The judge said that leaves a significant room for a range of responses. That is, in the moment, a judgment call. If it's not black and white and if it's not clear, then how are you meant to know what you need to do? You can see that this breakdown of serious misconduct actually helps us understand how we would apply it in a situation now when we are looking at what is serious misconduct. Is it deliberate? Is it not? So hopefully this gives you a bit of insight. And basically what I got from this is that it tells us very distinct guidance around terminations. The headline that I think a lot of people took from the Amendment Act coming into place was that serious misconduct means they get nothing. The employee gets nothing. As an employer, you only get this over the line if the label of serious misconduct actually holds. So 3 things for you as a business owner, as an employer, as somebody that's working in HR. 1 is that the facts under the label matter more than ever. Now when we're looking at serious misconduct, it matters about what's underneath. If your serious misconduct finding rests on a fact that you couldn't and you didn't nail down, the label collapses. And under Section 123B, which is the new regime, that means full remedies come straight back. The labeling era is now very binary. The second thing I would say is vague policies are now a genuine liability, and I mean very much so. Expectations you reinforce at team meetings but never write down, yeah, now's the time to write them down. If the rule leaves room for a range of responses, breaking it can't be deliberate. It's just not possible. So you need rules that are clear enough to be deliberately broken. And we know that when we're looking at a disciplinary process, it is will. Did the employee engage in this? And the third thing I would say is don't confuse defiance in the meeting with guilt at work. An employee defending themselves on reasonable grounds is not handing you serious misconduct. And this is what we saw out of that case. The contrite one and the stubborn one can be in exactly the same factual position. And that's why it's really important. So the worker in Johnstone kept her remedies, and like I said, this wasn't tested under the new regime. With that, they got $25,000 for hurt feelings, 3 months' wages, and costs. And the court noted, and this is the icing on the cake, everyone, the court noted that she'd have kept them under the new law too, because her conduct was never serious misconduct on any view of the evidence. If this was tested under the new regime, that one sentence is our indicator that these are the parameters that you need to work off of. That's the whole point. Section 123B, the new regime, is brutal when that label sticks, but the court has shown how carefully it'll check whether it does or not. So this is the kind of stuff, right? These are the tricky areas that you're navigating, the complications. When you're trying to have conversations, are you saying the right thing? This is the kind of thing managers can get wrong and leaders struggle with. And when you're dealing with it in real time, it's hard to fix from a policy document alone. And it's exactly why I train teams. And I train them on how to have confident conversations and what they need to do to actually understand the law, apply it, and get on with it efficiently and effectively. Like I've said to you in all the other episodes, my website launched and the workshops are now something that you can book. If you want your teams trained, send through an inquiry. It's lawlens.co.nz, and we'll move on to now what you need to do to make sure that you have checked everything off and done the right thing. Right now is your time to review your employment agreements and your disciplinary policies now. Serious misconduct is not defined under the legislation. It is not at all. What we go off of is case law. There is no statutory definition, which means that you need to set your parameters based on some of the things that I've mentioned today, as well as getting specific about what is serious misconduct for your business. If your policy does not clearly define what constitutes as serious misconduct in your specific workplace, guess what? You're letting the authority decide for you. If the matter ever goes to the authority, they will make that decision. So get specific, not just about theft and fraud and the stock standard. Think about your industry. Do you have health and safety risks that come up? Your trust requirements, what are they? Are there specific interactions that happen with customers? Things like that. What are the role-specific obligations? And start documenting any obstruction that happens in real time when you see it. This is something I always advised employers, even before this whole new legislation came in. I was always telling employers, what is the harm? Keep running proper processes. Do not let that change, because this is the most important thing I can say about these changes. If you failed to give an employee the chance to respond, didn't disclose evidence against them, or ran a sham process, you're still exposed and the risk is still there. So these changes won't save you from that. Before we get into the FAQs, I wanted to give you my personal take. And one thing that I read was actually from Frontline Law. I think it nails the employer risk on the other side of this. And they said for years, employers complained about paying go-away money to employees dismissed for genuine, serious reasons when a minor paperwork error occurred. That frustration, absolutely legitimate. Even I mentioned it earlier. But the concern being raised now, including by employment commentators and employee advocates, is that this change creates a license to be sloppy. If an employer knows they can potentially avoid financial penalties and things like that, that's where they're saying that some employers will be tempted to shortcut the processes and just to get to the outcome. Don't be that employer. But again, I don't think that that is what is going to happen with these processes. The employment court has consistently held that a predetermined outcome or a rushed investigation undermines the justification finding entirely, and we know that it can create an unfair process. Keep in mind that serious misconduct needs to be proven through a fair process, not asserted through a dodgy looking one. Now, we'll get into the last bit, which is your questions before I wrap everything up. And the questions that I actually got were a little bit varied on this one. The first one that I received was, what if our employee kept canceling disciplinary meetings and refused to engage? Does that count as an obstruction? Look, I would say that if they are constantly refusing to engage, they're not coming into the meeting, they're trying to derail, then yes, under the new act, it now works in your favor. And the authority does have to consider employee obstruction when assessing what's going on. But I would say, again, document it properly. Every time they decline, every time they cancel, send a follow-up email, note the date, note the reason they gave. And if you have written records of 3 declined meetings, 2 unanswered emails, that's evidence the authority can now explicitly take into account, right? They can't take into account rough ideas of, call logs or things that came up. Somebody else asked, we had one process gap. We didn't give the employee quite enough notice for a disciplinary meeting, but otherwise our process was solid and the dismissal was clearly justified. Are we vulnerable? Under the old law, that gap could have been a costly thing. Under the new changes, that defect will not mean that the dismissal is unjustified as long as it didn't actually result in the employee being treated unfairly. So sometimes you might run the meeting in a short amount of time. Maybe you have any further allegations or you want to give the employee more time. If the employee had more adequate time to prepare a response despite the notice being slightly short, that defect doesn't necessarily mean unfair. So you're in a much better position. That said, I would always mention get advice before you rely on this because the courts haven't really applied it yet. We have a rough idea, but not the real application. Somebody else said that we want to define serious misconduct in our employment agreements. What should we include? Well, include specific behaviors, like I said before. Anything that's relevant to your business. Don't do a generic list. I'm tired of seeing generic lists that talk about theft, fraud, falsifying records. Look at really what is in your industry. The standard ones we know, like I said, breaches of confidentiality, assault, harassment, bullying, all of those things. Those are all the standard inclusions. But think about the things specific to your role, to your industry. A safety critical role warrants a broader and more specific definition, right, than a desk job. So the definition in your policy creates a floor, not a ceiling. It's where you start from and build your way up. If this ever lands in front of the Employment Relations Authority, they can still find that other conduct amounts to serious misconduct if it meets the general threshold. But having those clear definitions, that is what's going to be the game changer. Somebody said that we went to mediation in January, the matter wasn't settled, we're now headed to the ERAA. Does the new law apply in that case? No. If the dismissal happened after February 21st, then that is when the new laws would have applied. In this situation, the dismissal happened before the Act came into place, which is the 21st of February this year, so that's why the old rules apply. Another question was, can we just label something as serious misconduct in our policies and rely on that label? Well, we've seen from cases that the authority will assess whether the conduct actually meets the threshold, regardless of what your policy says. What your policy can do is put the employee on notice that certain behaviors are not okay and they carry the most serious consequences, but the authority still makes their finding on the facts. And one employment law commentator really put it well. They said, the question is whether the conduct was capable of justifying dismissal in the specific context. So considering the role, the risk, the trust relationship, and whether a fair and reasonable employer could treat it as relationship destroying behavior. And the last question before we wrap it up, our workplace rules are mostly informal. We tell staff to use good judgment and act professionally, and we reinforce it at meetings. Is that a problem now? Yes, it is a problem more than it used to be, and it's because of that Johnstone case. You can only treat a breach as deliberate serious misconduct if the rule was clear enough to be deliberately broken. And that case showed that the policy was unwritten expectations to use common sense. That's not a really good policy. So the court said that that leaves room for a range of responses for judgment, which means that you can't necessarily break the rules, and breaking it couldn't really be deliberate. So if you want that true protection, your safety, escalation, and reporting rules need to be written down, and it needs to be specific. Vague expectations, not going to work, and that's where you need to audit your policies, and anything that boils down to common sense, spell it out. That phrasing is now a liability, not a safety net. Everyone, while I wrap this up, I just wanted to say 3 things for this one too, is that the 2-tier contribution structure that I mentioned, where we're talking about non-serious contributing conduct versus serious misconduct, we know that non-serious conduct removes reinstatement and compensation for hurt, humiliation. Serious misconduct removes everything. It's important to know the difference. The second thing is that you need to document your obstruction. So anytime the employee is derailing, obstructing, or doing anything like that, it's now legally relevant to actually write this stuff down and keep a track record of what's going on. And then the last thing is that these changes protect employers who try to do the right thing, not employers who cut corners and keep running processes in a very dodgy way. So 4 months on and the Act is in force, but the courts haven't interpreted the new provisions fully yet. And the next 12 months will be quite formative, because if you've listened from episode 1 until this episode in this 3-part series, you would know that things like the 200K threshold calculation, all of that stuff needs to be tested. And while we're working through all of this, make sure you take the time to audit whatever you can. I really hope that you don't wait for a grievance to land on your desk to figure it all out. You have the time now, and it's best to utilize it. That is it for this series. If there's one thing to act on, I would say employers who come out of this act ahead are the ones whose managers know how to run processes properly. And like I've said to you, it's what I'm all about. So go ahead, check out lawlens.co.nz. I offer workshops and I'd love to work with your teams on giving them the confidence that they need and should have to handle people situations, because leading people and employment relationships is hard work. It is hard, but it can be managed, and a better workplace can come from better compliance. Thank you so much, everybody. I hope you really enjoyed this series. It got into the detail and the nuances that you were looking for, and it gave you a better understanding of the laws and where they're at now. We'll see. Watch the space. If anything comes up that's landmark, groundbreaking, I will definitely bring it up, because that is what Law Lens is all about. Well, thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.